Well, good evening, everyone, and welcome to this event for London International Disputes Week on cyber fraud and data breaches in the era of remote working. My name's Tom Lingard, and I'm a partner in the dispute resolution team at Stevens and Bolton in the UK. And I'd like to introduce our panel, who you can see on screen today. We have Stephanie de Smet from Loyens and Loeff, and she's attorney of law, head of the Belgian IP and IT team, the data protection team, and the life sciences team at Loyens and Loeff. Ian Kay, who's just appeared to my right, who's head of cybersecurity consulting at Sopra Steria, and his colleague Raki Porter, who's head of resilience consulting, also at Sopra Steria. And then Matthew Levy, barrister at Four Pump Court, specialising in IT, and Ian Munro, barrister and mediator, also at Four Pump Court, who specialises in IT. So, yeah, thank you for joining. Tonight's seminar, we have an hour, so we're going to try and make it interactive, and we're intending to base our discussion around a fictional scenario and consider a practical response to a cyber security attack. We'll start with sort of firefighting, and then we'll move on to think about what precautions could be in place. And at the end, if we have time, there will be the opportunity for some Q&A, and you're welcome to submit your questions in the usual way via Zoom. We'll also put in a couple of polls as we go, just to gauge some of your experiences in this area. And we'll start with the first one now, which is just to ask amongst the audience, how many of you have had to respond to a cyber security attack in the last 12 months? No, you haven't. Yes, one, or yes, more than one. So do please vote now. I noticed in the Times yesterday, there was a report from BAE Systems that had found that of 400 British banks and insurance companies surveyed, 74% of them had experienced an increase in digital crime since the pandemic began, and over half had reported a real upsurge in financial losses, and they cost on average £575,000. 43% of the firms also said that employees working from home had really harmed their institutional security and made potential holes in their network and infrastructure less visible. So it's clear that the stats bear out what many of us have probably learned from practice, that the pandemic really has given rise to an increase in these type of issues. So hopefully now we can see the results of the poll. So no, 72%. Well, in that case, the majority of you will be forewarned rather than forearmed. Then about 20-30% have experienced one in the last 12 months. That may be an excellent reflection of your cybersecurity policies, but we'll see. So, as I mentioned, we're going to base the seminar today on a scenario which is this one. There has been an explosion at an oil refinery near Manchester, causing catastrophic damage to nearby buildings and infrastructure. The UK owners are now embroiled in an arbitration in London brought by a reinsurer with major exposure from the accident. $1 billion is at stake, and the sums are sufficient to make it market sensitive. And there are also threats of third-party claims outside of the arbitration. The arbitration is at the hearing stage, and they are mid-evidence. The owner's solicitors have just received a ransom request threatening to release a highly confidential accident investigation report unless they pay 20 Bitcoin, which at today's money, or possibly yesterday's money, who knows how fast it's risen, is about £800,000. The report was instructed by the owners for the proceedings and is legally privileged, and it's also extremely damaging to the case, which is why they didn't disclose it. The solicitors acting for the owners and their clients are trying to work out what went wrong and what to do next. So they turned to our panel for help. Now, we did think briefly about performing in character for this, but we've decided we're going to take more of a casual approach. So Raki, let's assume that the solicitors and the clients do have a plan of action already drafted. What would you expect it to include?
So let's make another big assumption that the people are actually aware of what the plan is, especially the person who's received the ransom and is being blackmailed. It's so common for these plans to become shelfware, leaving the person in the hot seat, not knowing what to do next. But what you'd expect from the plan is that it's adaptable for any scenario. It should be focused on the management of issues, decision-making, and the up and down flow of information across the business and externally. You're going to have so many different groups working together, the executive team, the IT department, comms, PR, finance, HR. The key thing is to make sure that they have an agreed command and control structure in place. Who are the critical decision makers and how quickly can they get updates on the situation as it evolves? In this particular scenario, at this point, the sort of options are countless. Is this a bluff, or do the perpetrators actually have the document? The crisis team will need to make the best possible decisions with the information at hand. So it's all about having the right people in the room who are empowered and can act fast. Secondly, the plan should include active logging of actions and decisions. There's no doubt the police are going to be involved and possibly regulators. So having an audit trail is key. I'd also like to make a specific point on communications that's sometimes overlooked. With the focus on keeping clients updated, there have been so many instances where employees have found out about an incident secondhand from the clients, or even once the stories made it onto the news. This is not good from a morale perspective, and there are reputational implications for the business as a whole. And finally, contact details. It's very much an old school notion to have a contact list in the plan. Ditch it. It's unlikely to be up to date. The best way is to make sure internal directory and your contacts on your phone are kept up to date, or set up a Teams site for crisis management team. So those are the things I'd expect to see in the plan. For it to be successful, it should be as close to normal working practices as possible.
Okay, great. Thank you, Reki. So as you mentioned, there needs to be a proactive incident response team, and the team needs to act swiftly. And as you mentioned, there are many different facets to response. So it needs to be multidisciplinary. We don't want to not have the right people in the room, be that PR, HR, whoever it needs to be. But a key part of any team will be the IT forensics, who'll need to investigate and, very importantly, contain the breach. So fulfilling that role for us today, we have Ian Kane, who's going to report on the scenario investigation so far. And in this sort of situation, Ian, how would you approach that investigation?
Yeah, thanks, Tom. So the first thing is to pick up on something that Raki said, which is let's validate that this actually is a threat. Is it really a threat, or is it just somebody who's doing a fake threat, what we'd call social engineering, to try and just extract money, but they don't really have the document? So we need to validate, is it a real threat? And the perpetrators of this do actually have the document, the report that they want to release, or is it just fake? Are they trying to socially engineer and trick someone into paying a ransom for somebody that they don't have? Now, to do that, first of all, we know what the target is, and that gives us a head start. We know the fact that this report supposedly has been extracted, so we know where to start, and we do that by looking at the system, the IT systems and services of where this report was stored. Now, the good thing here, the real key positive, is that the owners of the business, they recently invested in a monitoring tool set, something we call SIEM, Security Incident and Event Management. And what this does is it correlates and securely logs all sorts of things, all sorts of data and access from across an IT infrastructure. So what that enables us to do is to use forensic techniques and cyber analysis to correlate something that happens on system A with something that happens on system B, and get a picture across the entire environment to understand, was this document really exfiltrated from the IT system, or is something else going on here? And what we do to do that is look for things called indicators of compromise. And those indicators of compromise tell us exactly how an attacker may have got into the system, traversed through the service, and then get hold of this document. But throughout doing all this, we have to balance a couple of needs that sometimes conflict. So obviously, we have to properly identify the root cause of what happened here. We need to know how it was extracted, and was it really extracted to start with. We need to detect whether there were any further breaches. Some of these could be notifiable under relative law, but also we need to close the hole and contain the breach and prevent further attack. And sometimes those can conflict. So as an interim step, we produced some interim findings. There was a few things that we found to start with. And we found that the laptop of a partner in the law firm was actually compromised. Effectively, his young daughter clicked on a link online, found a free online game that she wanted to play. This had some malware included within it, some malicious code, and that downloaded onto the system of the partner and started scanning through and looking for documents. So there were a few key things that we found. And just moving on to those, the key item that we discovered was that this dropper, as we call it, this piece of malware, was scanned a significant amount of data, both on the laptop and on systems that this laptop connected to. But at the minute, these are only our interim findings. And one of the key things that we're unclear about is how this specific laptop was targeted to get this specific report. We know that the report was key and critical. We know that the laptop was used, and it was used to access the report. We don't quite understand how those two things were linked. So our investigations are going to continue. Two early lessons for us, though. First of all, working from home absolutely increases vulnerabilities. We kind of know that inherently because you have a business laptop, a business device that can be used by friends, family, whoever's in your house. And also your monitoring and your ability to actually defend against these threats is only as good as your ability to respond. In this case, although the company had that security event and information management system, they knew what had happened after the event. They weren't able to respond to it when it happened and prevent further breaches from occurring. So that's where we're at the minute, but our investigations continue.
Okay, great. Thank you very much, Ian. So as you mentioned here, and as we've sort of alluded to, home working does present a lot of issues, and we thought it'd be useful to have another poll at this point. And this is a poll to see if you can guess the results of a survey recently from the Cybersecurity Breaches Survey 21. So what proportion of UK businesses and charities have home working policies? A, around 75%, B, around 50%, or C, around 25%. So again, if you'd like to put in your educated guesses there, that would be great. And we'll come back to the results of that poll in a moment. But as an aside, Raki, what kind of issues are you finding from home working?
Well, I think, first of all, not all businesses have really been set up for remote working. I think they're getting there, but this leads to the use of personal computers, mobile devices that haven't been as secured. And then, as Ian mentioned, could lead to other people using those devices. The other factor is the management of confidential information. There have been so many instances of people printing confidential information on home printers and then, not shredding them correctly. And secondly, people find themselves working from home where, their housemates or spouses are working for competitors, which means having confidential calls is really difficult. There've also been instances whereby people have taken a break from home working and resorted to cafes or public spaces where there is a threat of being overheard or overlooked. And then lastly, responding to an incident sort of virtually is even more difficult when you aren't sort of huddled in the same room.
Yeah, absolutely. I mean, from our experience as well, even things like when employees leave, getting the IT equipment they've had from the company back again, all those sort of things come into play. So exit policies and things as well are really important. So looking at the results of the poll, 25%, yes, you're right. In essence, the results of the survey suggested that only 23% had cybersecurity policies that covered home working. So we've all had to adapt a lot to home working, and there's obviously some policies that perhaps need to be updated too. But Ian, you've found out about the compromised laptop. So moving on a bit, was that in fact the problem?
Well, so it's an interesting one. And just before I come on to that, there has been a question asked, which I'm going to duck onto just for a second. The question is whether or not we could just ask the attackers for proof of life, that extract from a document that proves they have it. In theory, yes, absolutely you could. The challenge is that with some of these attacks, or with a relatively large portion of these attacks, there is an automated element of it. There aren't people sitting there manually trying to attack individual systems. And certainly with ransomware and with those kind of attacks that encrypt large amounts of data on victim systems, what we often find is that the encryption is just irreversible and the attackers have no interest in engaging. It's just a numbers game. So you could ask, but the ability to get them to engage is a little bit unlikely. It's better to independently validate the truth of it. So thank you for that question. So Tom, returning to what you said, the access to a work laptop and that ability to share, or that inherent risk of sharing work devices in certainly in the current environment is an issue. It's an immediate problem, and it's also what we'd call a ways of working cultural issue. But the attack itself, this attack in this case, with further investigation, it turned out to be much more sophisticated than we first thought, and a number of different vectors, a number of different approaches were actually used. We're going to illustrate this because there are a number of steps. So first of all, the thing that really triggered this was an email. So this email was received from the junior counsel, who was urgently looking for a document, this report, because they thought it was relevant to some ongoing testimony. And as you can see, it's just a fairly standard email saying, urgently, I need access to this document. Please, can you send it to me because my IT system is just not working. Pretty standard. I'm sure everyone has had a situation like this. Oh my word, I need that document really urgently. Can't get to it. Please, can somebody email it to me, send it to me, Dropbox it to me, something like that. So this was really the root cause of it, the trigger of the actual compromise. But how we got here was a little bit more complicated. So the first thing is, if we just move on to the next bit of investigation, we found that the solicitor's email service was compromised. And the way that this was done was using a zero-day flaw. And a zero-day flaw, a zero-day attack, is something that exploits a new and unknown security flaw or vulnerability in a piece of software, a service, a system. And the reason it's called 0 day is because it's unknown. It's been known for exactly 0 days. And this was a very sophisticated attack. It was an attack that was supported by a nation state. In fact, the cause of it was quite widely reported in BBC News and in mainstream media. Certainly, if you may have heard of it by listening to or reading BBC News yourselves, but it is there on the BBC News website if you'd like to read some more about it. But what we found is that this nation state supported attacker used this new security flaw to compromise the solicitor's email service. That was the first part of the attack. And essentially what we were able to use is the security logging system, that SIEM platform that I mentioned earlier. It showed us the flow of the attack, how this attack searched through inboxes and file storage, and having compromised that email service and compromised that IT platform. The pattern of it showed an attacker specifically looking for the report. Now, the interesting thing in this case is that the report was not accessible from the systems that the attacker compromised. It was secured elsewhere. As we know from the summary and the brief at the top from Tom, it was actually secured in an online cloud storage system. So that wasn't accessible to the attacker. What was accessible, though, was the arbitration timetable and the contact details of the parties involved in the case. And it was these details that were stolen. And this is how an attack begins to get set up. So as we move on to the next piece, those stolen contact details identified a target for this attack. They said who may be able to be compromised and who may have access to this report so that the attackers can get to it. The arbitration timetable gave a plausible scenario. It gave a reason and a meaning and something that people would believe if they were asked for this document in this kind of scenario. And to further this attack, the attacker registered what's called an off-by-one domain. So essentially, the attacker looked at the email domain, the website of the chambers, and they registered a domain that looked very, very similar. As you can see on screen, the domain that was registered was law-chambers.com, where the genuine domain was just lawchambers.com. And I'm sure all of us have not looked very closely and in detail at our Outlook emails when opening them up, just to see if there is something there that looks quite right, but isn't right. And essentially what the attackers did was use phishing and social engineering to trick the solicitor with this targeted attack. So they had a targeted message. They used an off-by-one domain to make it look even more real. They gave plausible context, and they applied pressure to the victim. And one of the key reasons that they used this off-by-one domain technique is because although they compromised the solicitor's email service, that could have been patched and secured at any moment. Initiating the attack through an off-by-one domain means that the attacker retains control of that off-by-one domain and therefore immediately receives replies and responses, emails to it. Makes it much easier and much more straightforward for the attacker to really exploit their victim. So just in summary, because there's a number of steps that are quite complicated, there was a really clear flow and progression which we can show now. First of all, we started off with a 0-day exploit on the solicitor's email service. That's what let the attacker in. They performed reconnaissance and identified where they could get the document because that document wasn't directly accessible from the systems they compromised. They weaponized a domain. They registered an off-by-one domain to trick their victim into communicating with them, and then they spoofed the council's details and used them for that targeted phishing attack. But the key thing here, and the key reason that this attack worked and that the attackers were able to extract that document, was one simple thing: human error. The council's IT systems were never touched, were never compromised, were never attacked. This was all done on the solicitor's systems, and it was all done because of human error, and a mistake was made when looking at this email, and they fell for the phishing attack.
Great. Okay, thanks, Ian. So we know, the solicitors know that the attackers have got the report, and they know how they got it. So what should they be doing now to secure their systems and contain the breach?
So this is a difficult one because you've got to balance containing the breach with, potentially anything that you may wish to do in the future to address that breach, to maintain your business operations, and to actually address the attack and the whole issue of losing the report in the first place. But broadly, there are some key things that you would do. You would check for further indicators of compromise. Make sure that you haven't missed anything. We already found one root cause at the start, which turned out not to be the root cause. Let's make absolutely sure that we know that the root cause, the true root cause, has been identified. We have to urgently isolate the systems as quickly as we can because we don't know what further compromise, what has been left behind on those systems that could cause us problems in the future. And we should enforce changes of credentials, make people change their usernames and passwords so that if anything has been stolen, we're again mitigating that risk. And there are some other tactical, technical things that we would normally advise organizations to do. And these are quite low-level, detailed, and technical cyber things, but there are always these technical controls that you can implement to help defend against the issue quickly. But the final thing that I would always say to do is to communicate widely and clearly. Confusion only helps the attacker because people don't know what they're supposed to do. They don't know if something is okay. And in that confused environment where communications is unclear, it is ripe for further attacks.
Yeah, understood. And in the event of the data breach, one of the key questions is which third parties also need to be notified, which then brings on the question of, well, how do you do that and when should you do it? So the owners already know about the report, but the extent goes further than this, and the whole email account, as you mentioned, has been compromised. So the report is the tip of the iceberg, really. So with that in mind, your mind's turned to next steps. So Ian, your investigations have revealed a sophisticated attacker, in this case relating to a nation state. It may not be in every case, but one question that often arises and that we get posed is, well, should we be reporting this to the police, and if so, when?
Certainly. So I can't comment on whether you should report it to the police or not, but in the real world, reporting it to the police will not solve the problem. It will create awareness of the problem. It won't solve it. The key action is stopping the attack, protect the systems, and engaging with the police won't necessarily help with that.
No, I mean, there are, as you say, there may be reasons why, and it's good practice to do so anyway, for example, Absolutely. For insurance. And as Raki's talked about, making a log of decisions to show that all the right steps are taken at the right time. But yeah, it won't be a silver bullet, certainly in terms of speed. That's great. Thank you. So what about regulatory notification, Stephanie?
Well, from a regulatory perspective, cyber attacks very often, of course, cause breaches of personal data within the meaning of data protection legislation, such as GDPR. Now, two notions are important there, the notion of personal data and the notion of a breach of personal data. So personal data basically covers any data, any information relating to an identified or identifiable physical person, a living physical person. So not only direct identifiers such as someone's name or telephone number or email address, but also anything that is indirectly relating to that person and could identify that person. And then we talk about a breach of personal data as soon as there's any kind of incident that actually leads to the accidental or unlawful destruction, loss, alteration, disclosure, access of such personal data. So the definition is actually quite broad. It's not just hacking attacks. It's not just having data disclosed to malicious attackers. It's really any kind of destruction, loss, alteration, access to personal data where this was not what your initial intention was. So for example, we have cyber attackers that use ransomware to encrypt data so that data becomes unavailable to the company. That would qualify as a personal data breach. But also in the case at hand where cyber attackers gain unauthorized access to email accounts or entire company IT system, they gain access to confidential documents that may also contain personal data. That would be a breach within the meaning of data protection law. Even if in our case at hand, the report itself would not contain any personal data, the hackers did potentially have access to email accounts, to thousands of emails, to IT systems. So we're pretty sure that there were also personal data involved. Now, unless you can reasonably defend and argue that the personal data breach is unlikely to result in any risk to the rights and freedoms of the physical persons, the individuals concerned, you will have to notify the data breach to the relevant authorities. So there's a general data breach notification obligation unless it is unlikely that there is a risk to the rights and freedoms of physical persons, which is of course very difficult to demonstrate, and which authorities are also very reluctant to accept. So in most cases, you will need to notify data breach to the authority, and you will need to do that in case of data protection authorities within 72 hours of becoming aware of the breach. Of course, you can argue about when have you become aware of a breach. Is it because one employee is aware that the entire company and leadership is deemed to be aware? For example, a data breach can also happen at a subcontractor, at an IT service provider. When are you aware? As soon as they are aware, or only as soon as they inform you? So there's a lot of questions there, but general advice is, even if you're not 100% certain yet whether there is actually a personal data breach, even when you're still figuring out the details, carrying out with your technical investigation, the best thing to do is to immediately already file a preliminary notification with the data protection authorities. That's also what they expect, even if you don't have the details yet, that you file a first notification within those 72 hours, and you can always further complete it afterwards. Quite recently, there was a case in the Netherlands where the company Booking.com was fined. They received a fine of almost 500,000 euros for notifying the Dutch Data Protection Authority 22 days too late of a data breach having occurred. So they were probably still figuring out how to notify and what to include. But in the meantime, those 22 days had passed, and they did receive an administrative fine for having notified too late. So, what to include in a data breach notification, that's also something that differs quite a bit from country to country. In Belgium, for example, we have a very elaborate data breach online notification form. So you can go to the website of the authority, you fill in the electronic form, it's very detailed, you can file it. I know in other countries, there's really no templates or no clear guidelines on how to file a notification. So it can be very, very short, and you would not need to include a lot of details, but it's really something that you should take into account. Also figuring out where do you need to notify, in which countries. If you have a shared IT system that is used both by your UK entity and your European branches, how and when do you notify? Do you notify in the UK and in the EU? Do you notify that at the same time? If your company is active in certain industries, certain sectors, you would also need to notify not just the data protection authority, but also your industry-specific regulator. For example, in financial services, for telecom services, or any services that fall in the scope of the Network and Information Security Directive that are deemed essential for society. So there's quite a bit of industries where you need to notify not just the general data protection authority, but also specific regulators. So those are things to definitely think about.
Yeah, absolutely. And it's not just about regulators like that as well. There's also the need to consider your data protection obligations to your clients and customers under the legislation, leaving aside contractual obligations.
Yeah, exactly. So even if you notify the data protection authority, that will sometimes not be enough, where the data breach is also likely to result in a high risk to the rights and freedoms of the persons concerned, then they need to be notified as well. And in principle, they need to be notified individually. So they would need to receive an individualized email, for example, notifying them of exactly what kind of data relating to them were breached. Only if this would involve disproportionate effort, you can replace these individual notifications by a public statement. Now, of course, again, it's quite difficult to assess whether there's a high risk to rights and freedoms of physical persons. So what is useful there is there are guidelines that were issued by the European Data Protection Board, and they issued quite extensive guidelines on when is a data breach presenting a high risk, when is it not a high risk. So they do present some case studies there that are useful to make that assessment. Of course, in their document, they use the cases and the examples that are more black and white, and they stay a bit away from the large gray zone. But for example, in case of malicious data exfiltration, as is the case here, or where sensitive personal data such as passwords are compromised, you will need to notify the persons involved so they can, for example, take immediate action to change their password. So in our fictional scenario, both the employees and the clients will potentially need to be informed. And of course, at that moment, again, it will be important to involve your PR team as well to keep in charge of the narrative, of course.
Yeah, that's often when the general public find out most about data protection breaches, when there's a large news article about a very large business that suffered a major breach. So thank you, Stephanie. And Matthew, the firm will also need to notify its own regulatory body as a law firm.
Yeah, probably will, yeah. And then a query, I suppose, also, whether in addition to notification, there's a breach. I mean, of course, you've got the Code of Conduct, section 6.3, haven't you, which is the obligation to keep the affairs of current and former clients confidential unless the law says otherwise or unless you have consent. Now, obviously, that's not really driving at this sort of thing. What that's about is thou shalt not misuse your client's confidential data for collateral purposes. But you know, in the right circumstances, and we still haven't quite unpacked why, for example, the zero-day attack happened, how soon after day zero it happened, and whether actually one might be in a situation where there was to its highest, a casual disregard for IT security. And the inquiry actually is 6.3 engaged. And of course, there are, in addition to the regulator, you've got your insurers. Insurers have been mentioned already, but probably one of the most important people you're going to want to be speaking to are your indemnity insurers, if you've got them, your cyber risk insurers. And of course, clients. Stephanie has raised rightly the point about speaking to clients about their personal data. And so that's sort of the regulatory aspect. But if you're a commercial law firm and your entire email server's been hacked, there's an awful lot of client data there. I'm just setting aside the personal data stuff. Clients are going to want to know, aren't they, that potentially their confidential trade secrets and other commercially sensitive material is potentially out there waiting to be sold to the highest bidder.
Yeah, absolutely. So, yeah, you mentioned the insurers and potential liabilities then. So, you know, what might the firm face in terms of third-party litigation?
Well, look, we're at early stages, aren't we? So we don't yet know what the full content of the solicitor's email account actually was. We don't know what's missing. We don't know what's been taken. But let's make some assumptions. So starting with GDPR claims, since Stephanie's given us a great intro to the GDPR issues, if there's a large amount of personal data there, I mean, let's take an extreme example, but not a far-fetched one. Let's say the solicitor's dealing with a consumer banking case and has a large list of individuals' bank accounts sitting in the email somewhere. Then there's certainly in this jurisdiction at the moment, the heady possibility of a group action. And of course, as the law here currently stands, the claimant can recover compensation without having to establish any actual loss. That's the so-called loss of control damages, whereby the mere fact that your data has been lost can be measured in monetary terms and sounds and damages. And again, as the law currently stands, there's the possibility of an opt-out group action. And that means you may be facing a well-funded and well-resourced action, which might be hugely costly to deal with. Now, whether this risk survives the Supreme Court's decision in Lloyd and Google is, well, let's just say it remains to be seen. We'll know later this year. But if it does, then that is a barrel you're looking down. And of course, let's move away from data protection claims, because they're only one piece of the pie. There may well be contractual or even tortious liability to clients, breach of terms of the retainer, what's in there about IT security and keeping things confidential, or frankly, query a reasonable skill and care. Again, it depends what's actually happened and how this has been allowed to happen. You've got potential breach of confidence actions, potential professional negligence actions, and quite an interesting and potentially unpleasant possibility, depending on who your clients are, is a sort of chain of indemnities. If clients are themselves facing upstream claims because they have sensitive data belonging to third parties, which were on your systems and have now been hacked on your systems. And then finally, let's not be all defensive. There are the offensive claims. It may be time to sue your cybersecurity provider. So let's dig that contract out of the drawer and then look at the exclusion clauses first. But first things first, though, we are going to have to review confidentiality provisions owed to clients, steps that needed to be taken to preserve sensitive information, and one needs to think about industry norms in this context. So, and I think here I'm moving dangerously out of my comfort zone, but very much into yours, Raki. So can you talk to us about industry norms? What are the norms about avoiding inadvertent disclosure, the sorts of steps people should be taking in these sorts of situations?
Yeah, absolutely. So for me, it's really twofold. There's the behavioral side and the technology side. So let's start off with, from a behavioral perspective, it's all about training and awareness. You want your employees to know that if it doesn't feel right, it probably isn't. And there's a lot of training and awareness that goes into that. This also means that the business needs to have the right policies and the ways of working in place that allows for securely transferring data and everybody to be following that. And then from a technology perspective, you need to have data loss prevention solutions and the right DLP controls in place. And that's, there's a number of things that you can do in that space.
Sure, great, thank you, Raki. So Ian, what can the firm now do to defend against these potential actions?
Well, the first and most important thing is going to be Ian's work, trying to work out what's happening. That's the immediate focus. But all the actions that we've been discussing so far, they need to be undertaken with really a view to what happens next. We should be gathering evidence, preserving evidence, but also taking a record of what's been done. And that, of course, comes back to what Matthew's said earlier, which is we need to take a look at the obligations we actually owe to our clients to work out, therefore, what we should be recording and preserving. From a client perspective, obviously, one of the key things is to preserve legal privilege where possible and avoid inadvertent waiver. And although this may seem obvious, it's often overlooked. For legal advice, that really involves keeping lawyers involved when you're discussing potential liabilities situations. And it also involves limiting the circulation of the advice to those who are actually authorized to seek it, and then telling those people not to forward on the advice to a wider group of people. Again, these are behaviors which might seem obvious, but I guess are forgotten in the heat of the moment. The other thing to bear in mind is what one should be doing with people who, for example, are suspected to be involved or not. Maybe not just kind of complicit in the activities, but perhaps personally liable for making a mistake. That's obvious, obviously. That's obvious for an inside job, but imagine outside of this scenario, the junior counsel is the person who inadvertently sent it on. And so the firm may actually have a claim against him or her. Well, in those circumstances, you would want to think very carefully about who's in the loop and whether that junior counsel is involved in the sort of legal team discussions that will be taking place. In terms of expert investigations, those communications and reports obviously only attract litigation privilege if the dominant purpose is contemplated litigation. That means, I think in the case of Ian's work, probably they aren't going to be privileged documents because his focus is necessarily on stopping the attack and remedying the position. But in a bigger scale data breach, maybe that's what we're discussing here. It may be proportionate to get around that issue as a crisis team to have a separate expert essentially monitoring and investigating the position, but doing so really from the perspective of anticipated proceedings. What that may mean is that your expert, your sort of potential testifying expert, gains a first-hand insight into what's happening and therefore may indeed get the edge over their opposite number if this ever goes to court, because they'll have that higher caliber of knowledge. There are wider matters to consider beyond litigation and legal advice privilege when you're considering the evidence trail. For example, protocols for video conferences, confidentiality and the like, and also discipline when it comes to email and instant messaging, because I think those who've been involved at trial often see that a future factual witness may later regret a half-baked opinion as to who's to blame. And those sorts of things are best avoided through cultural change. But obviously there's a balance to be struck here because there needs to be clear communication to fix the problem. And fixing the problem is the best defense against a substantial claim.
Yeah, sure. So, and what about going on the offensive? What can be done about the perpetrators of the attack?
Well, taking it very briefly, that we may have tortious actions, we may indeed have criminal offences to pursue at a kind of state level, but none of that is likely to lead to a practical response to the owner's problem, or indeed the firm's problem. So little, practically speaking, against the perpetrators. So the question then turns to whether there's scope to negotiate with them, as unpalatable as that sounds. My suspicion is that's likely to backfire here. But Raki, what's your view on that?
Well, firstly, I'd expect the business to have a firm view on whether they negotiate or pay ransoms, and this should be known to everyone in the company. Many organizations will have made a decision not to pay any ransom in any situation. And this is advice from the likes of NCSE, the police, and would also be my view. So firstly, it's because there's no guarantee that you will actually get your data back. And secondly, it makes you a target for the next time. There's so many incidents where a company has paid the ransom as it firstly wasn't a huge amount. They got their data back and then the perpetrators came back the following week with a much larger demand. So setting any precedent isn't really advised.
Oh, okay, understood. So let's say the owners don't want to comply on our good advice with the extortion demands, but the report is released the next day and there's a suggestion by counsel on the other side of the claim that they're going to rely on it. Matthew, what are your thoughts on responding to that and the steps that could be taken in anticipation of litigants and potential claims taking the same position?
Well, obviously, after the stream of invectives passed, I think the trouble here is in English law, we don't have the equivalent of that wonderful US expression, fruits of the poisonous tree. So the mere fact that the evidence has been obtained illegally doesn't necessarily of itself mean you can't use it. Of course, we're in arbitration here, so it's going to be a matter for the tribunal's discretion within the scope of whatever institutional rules may apply as to whether illegally obtained evidence is actually going to be allowed in. Insofar as it's possible to detect trends in international arbitration, and of course, given that so many of the decisions are confidential, it's a potentially a fool's errand, but I'm going to do it anyway. There does seem to be a tendency to allow evidence in unless the party seeking to rely on it is actually involved in the wrongdoing. And then for very obvious reasons, general rule, so no doubt exceptions, but obviously a tendency to exclude. Now, we don't know for sure, do we, in this case, whether the attackers who managed to get hold of this report were in fact associated with the other side or not. So how that plays out is yet to be seen. But of course, there's another critical factor here. On our scenario, the report's privileged, and that does change the game, luckily. We've got, let's assume the IBA rules, the International Bar Association rules are applying to this arbitration. You've got Rule 9.2b. The arbitral tribunal shall, at the request of a party or on its own motion, exclude from evidence or production any document, statement, or testimony or inspection for any of the following reasons. B is legal impediment or privilege under the legal or ethical rules determined to be applicable. Now, in an English seat arbitration, you're okay, because if the document is privileged, that is a reason why under Article 9.2b, it ain't inspectable. So we should be all right.
Excellent. But the firm may well find itself subject to a investigation by the ICO or their local regulator in other circumstances. Stephanie, could you perhaps just briefly explain the likely implications, from your experience of that?
Yeah, sure. So in general, and unfortunately, the data protection authorities don't really have a uniform approach in how to deal with data breaches reported to them. Generally, they don't really have that many resources. So we do note that they don't have the human or financial resources to investigate or examine every breach that is notified to them. So they have to make certain choices, set certain priorities, especially in some countries where we've seen that the regulatory authority has really been flooded with data breach notifications. From companies taking the approach of let's just notify every single little thing, and then they're so flooded in notifications that they won't be able to examine anything. In some countries like Belgium, where we have this electronic notification form, it's quite easy for the authority to make certain cases prioritized because they have certain triggers that are built into the notification form. For example, when you click or you confirm that sensitive personal data has been compromised, you can also confirm whether there has been any data exfiltration, whether there was a malicious hacking attempt, the number of data subjects or data records that were concerned. Those are all things that are automatically analyzed and can then be used as a trigger to start an investigation. So the Data Protection Authority may very well, just on the basis of a breach notified to them, decide to open up an investigation as to the cause of the breach. Was there a problem with the company's cybersecurity, data security? How did the breach actually happen? And is the company to blame actually for the cause of the breach? Now, on the other hand, not every data breach happening is necessarily a regulatory issue or necessarily means that you have not complied with your data security obligations under GDPR. So it's definitely not because you notify a breach that you would afterwards be sanctioned for not complying with your data security obligations. Of course, human error does not necessarily imply any structural security flaws within the company. On the other hand, data breaches that are notified do often reveal a company's weak spots in terms of security. So we do see regulatory investigations happening after breaches are notified. On the other hand, we also see that investigations can follow from a complaint by a data subject, a person that was the subject of the breach and that was notified of the incident and then filed a complaint. So investigations can come from different ways.
Great, thanks, Stephanie. So we've talked about the aftermath of the attack, but this wouldn't be a legal seminar if we didn't talk about being prepared. So that is a key part of an effective response. So I thought it'd be a good opportunity to do a further poll now, which is when was the last time you stress tested your crisis plan? A, in the last 6 months, B, in the last year, C, in the last 3 years, or stress tested are what? ? So we have a quick look through the results of that once everyone's had a chance to vote. let's see. Oh, that's good. In the last, pretty, and it's just, that's all, 80% within the last 12 months. So that, to me, as a layperson, that sounds pretty good. But Raki, what could our firm have done to be more resilient?
So being resilient is all about having both preventative and responsive capabilities. So stopping the incident happening in the first place and also being prepared for when it does happen. So in this particular scenario, the firm fell victim to a social engineering attack whereby the perpetrators requested information pretending to be the junior counsel. Instead of emailing the document, the solicitor should have actually picked up the phone to the junior counsel, given that they would essentially have been breaking protocol. Secondly, even if this was a sort of genuine request from the junior counsel, the solicitor should have advised the junior counsel to resolve their technical issue, given the sensitivity of the data. So this really all comes down to training. And we've all been through mundane cybersecurity training, and it doesn't always work. There's so many different ways in which people learn these good behaviors, and investing in our employees to become more cyber savvy has never been more important. Our employees can be the biggest strength, not the weakest link. So one way of doing this is by broadening the net to those who you would typically involve in a crisis exercise, get near to everyone involved depending on the risk and cost, and use alternative methods such as VR or gaming theory, and perhaps build it into your away days. There's also technology solutions that could be implemented, but for now, I'll leave it at that.
Okay, thanks, Raki. And what about the lawyers, Ian? What role could they play?
Well, I mean, in our scenario, obviously, we're dealing with a law firm, so a very big role. But imagine a situation where the lawyers occupy more of a kind of in-house role in an organization that does widgets. Well, lawyers are going to play an important role in cultural change. It starts with drafting some proper cybersecurity obligations into employee contracts, but obviously it continues in terms of their roles in training. Raki's right that it can't just be limited to a legal seminar about what goes wrong, and has to focus on behavioral aspects, but a lawyer will be a further check, a further counterbalance. In our scenario, I think it would have helped our crisis team if there was just a fuller record of the sorts of obligations that erode to clients in terms of data, and in the case of a breach. And that's not just going to be standard obligations, though, because they may be amended for particular clients. So it needs to go down into the granular detail so that the crisis team knows where the particular vulnerabilities are. And so, boring as it may sound, there are some administrative tasks that lawyers can help identify and indeed carry out to make sure that the relevant information is at the fingertips of the crisis team when the crisis hits.
Yeah, absolutely. I mean, one of the things we come across very often is that clients don't really appreciate where their confidential information is and what it is, and they don't take as many steps as they could in terms of limiting access. So, and one employee might have access to an entire internal system when all they need is a limited access to the marketing database, and it's in those scenarios that employees moving around can get more information than they really should have access to. So thinking more generally about data protection, then, Stephanie, what would be the top tips for preparation in that respect?
My top tip would be make sure that everyone within the organization actually knows what a data breach is. They don't need to know the details, but they need to recognize a data breach. And more importantly, even they need to know who to inform internally. So they need to know who within the organization they can turn to when they suspect a data breach, when they see something fishy, and they need to know where to report. And then that person really needs to be aware of their legal and compliance obligations. So you do need a person within the company that knows, okay, I have 72 hours. To which authorities do I need to report, and what do I need to figure out within those 72 hours? So also from a data protection perspective, I would say awareness training are really key.
Great, thank you. So, I mean, in the aftermath of any cybersecurity attack, an organisations will need to take stock. We've mentioned before how one can follow quite hard on the heels another. And in the time available this afternoon, we haven't been able to exhaustively cover absolutely everything that could be done, both in terms of preparation and response. But I think perhaps that just illustrates what a big and potentially sort of important issue this is. So before we just draw to a close and invite questions in the few minutes we have left, I just wondered if any of you would like to sort of mention if there are any sort of experiences that our unfortunate fictional firm of solicitors can draw, and their clients can draw from the experience of this attack.
Should we go around the table? I mean, who's going first?
Well, you've unmuted first, Ian. You go first. Sorry, Matthew, you go first.
Ian.
No, thank you, Matthew. So I think I could talk for many hours about cybersecurity and the things to do, and I could bore everybody at considerable length. But I think one very important thing in everyone's personal and professional lives, we hear it all the time about people being scammed out of money through bank transfers, phishing attacks, get scammed out of data, and in all of these kind of things. The fact is, it works. And what everyone should remember is that email is a 50-year-old technology, and it was never designed to be secure. Similarly, phone caller ID on phone calls, text messages, all of these platforms can be easily faked. They can be easily spoofed. So in your personal and professional lives, if you get a message that adds time pressure to you, that asks you to do something that is just maybe slightly unusual, take that extra second to step back, think about it, and validate, so you can trust but verify it.
Thanks, Ian. Sorry, Matthew.
Yeah, I mean, following up really actually on what Ian's just said, the problem with us as disputes lawyers is we all think we're far too clever to fall for this sort of social engineering attack.
It's obviously not true, isn't it?
We're really, really not. And of course, we need to be particularly aware because we're particularly vulnerable, particularly when, say, in a hearing scenario, when we can be working under really very extreme pressures. Taking that extra second is, of course, the right advice. I can guarantee we don't do it when we're at the pressure of a hearing, we're desperate for a document. And that's why actually one needs to engineer in structural solutions. By all means, of course, you must train, of course, one must bang home these messages. But the reality is people are always the weakest link, particularly the lawyers.
Yeah, exactly. And Raki, how about you? Have you got any points?
Yeah, I think just to Matthew's point at the end, yeah, absolutely, people can be your weakest link, but that's why I think preparing and that, preparing is really the key thing here. These things are definitely going to happen. They're already happening to so many organizations, to people personally. So it's all about knowing what to do in those circumstances because they will happen. So for me, it's all about preparedness.
Great, thank you. And Ian?
Yeah, I think taking the extra second also applies to the crisis response situation and making sure you're not sending off emails where you are going to be a little bit embarrassed in future if they happen to be disclosed. Having an eye to what could go wrong if you're being cross-examined long term. Sure.
And Stephanie?
Yeah, from a data protection perspective, also the documentation is really key. So I would say for every data breach, big or small, see it as an occasion to really reassess your level of protection of data and to really be able to demonstrate that your data security standards are adequate in every step of the way and that they are really reassessed on a regular basis.
Yeah, absolutely. Thank you. Thanks all for those extra thoughts. We've got a minute to spare. We've got one question, or not so much a question, just an observation, which I think is worth noting, which is that as lawyers, we have our own data protection and data security issues, but increasingly, and this scenario was one where it was data shared with counsel as a problem. But that's just one of the people with whom lawyers will share data. There's disclosure platforms, other lawyers, investigators. There's a real, you talked earlier about upstream claims. There is a real sort of a whole group of people for whom we're the nexus as lawyers in dealing with these issues. So checking those contracts might be something that we can do to protect ourselves, even if we don't know where the next attack is coming from. So as the clock ticks over to 6:30, and in the absence of any other questions, I'd just like to thank very much our panel, Stephanie, Raki, Matthew, Ian and Ian. And I'd like to thank you all again for joining us in London International Disputes Week. There are a number of other seminars coming up over the coming days involving both Stevens and Bolton and Four Pump Court. So do check our websites and other social media outlets for details of those if you'd like to sign up. And so, yes, thank you very much for joining. I hope you found it useful. Thank you again to our panel who appear in glorious Technicolor before us. And with that, we'll wish you all a very good evening. Thank you.